Massive gun control could be coming. There could be a point where we look back and say, it was this case Tom talked about in this video, which might be going to the United States Supreme Court. I'm going to be explaining to you what's going on, what's at stake, and I'm going to just make the 1, 2, 3 dots so that you can connect them. Guys, there's a lot on the line here. Let's get into it. So what is the sneaky gun control that we're talking about here? So courts, as you know, rule ball and strike when it comes to whether or not a law or regulation is impacting the Second Amendment. But it's not just the outcomes you need to be worried about. Let me give you an example here from the case we're going to be talking about a little bit later. The case is talking about public transportation in Illinois. Probably not something you or I spend much time thinking about. Thankfully, not something we need to be spending much time thinking about, except we do. Here's why. Court goes to a federal circuit court of appeals. That's one step below the Supreme Court, all right? So we're in the 7th Circuit Court of Appeals on this case. And on the one hand, maybe you live in the country, maybe you live in the suburbs, mass transportation, not a big deal for you. But you have to look at what's the wording and reasoning these courts are using in order to justify some particular, maybe it's obscure and you don't care about it, gun control measure. Because the reasoning that they adopt today becomes the road that they will then roll down all future gun control on. And this case is going to be a perfect example of that. It's not so much that this case in and of itself is some sort of doom and gloom or anything like that. It's pretty narrow, and it's realistically only going to affect people, for the most part, in major cities. But the secondary effects, the second order effects, in other words, not immediately what is it doing, but what is it setting up next, are very big. And that's the sneaky gun control, because you don't realize that second part is coming until you're now fighting at your second line of trenches and you say, they totally put this in here to screw us down the road. That is where we are. We're at that first line of trenches where they're going to set up and say, yeah, well, this is okay because of these reasons and this way of thinking. And if you buy on that, then I got news for you. The whole truck is coming next. Like a Costco size amount of gun control is going to be coming next based on this reasoning. And that is why you should absolutely care about Illinois transportation law. Let's take a look at exactly what they did. So the case is linked in the description box down below. I apologize if I mispronounce any names. I've clocked this as Schoenthal or Schoenthal versus O'Neill Burke. But the bottom line is we're talking about Firearms Policy Coalition, who put together a bunch of plaintiffs who were all licensed Illinois concealed carry holders, and they challenged the state's public transit firearm ban. Not restrictions, ban, arguing that it deprived them of their fundamental right to armed self-defense while traveling in public. After all, hard to defend yourself against a group of people with knives, baseball bats, whatever, if, you don't have a firearm, you're outnumbered. And remember, about 90% of the time when bad guys are attacking you in public, they do not have a gun, according to studies, okay? So that's relevant. So these plaintiffs claimed that the restriction was unconstitutional under New York State. This is the Brune attack, right? 2022, United States Supreme Court, the Brune. New York State Rifle and Pistol Association versus Brune, who set basically the goalpost for determining whether or not something is going to be found to be constitutional or unconstitutional as, and this is low resolution, but it's pretty good for us here today. If there is no founding era or early republic era or anything like that, historical analog, in other words, a law that's really similar to what we're talking about, specifically banning firearms in forms of public transportation, and there are none. Therefore, this law is unconstitutional. They argued that emphasizing that each plaintiff would carry a concealed carry handgun on a public transportation for the purpose of self-defense, if not for the ban, and as a result, the threat of arrest and prosecution. Illinois defended and responded to this claim as a natural extension. See this secondary thing? Anytime you hear a natural extension, we're talking about second order effects, all right? As a natural extension of restrictions in sensitive places. Now remember, Brune said sensitive locations. We're talking about polling stations, schools, legislative bodies when legislature is in sessions. That's what we're talking about. And they cite that here. We're talking about schools and courthouses. Noting that, however, here's the line getting pushed. You ready for it? Transit is crowded, confined, and difficult to police. reasoned the judge, writing for the majority, saying that this, quote, the Second Amendment protects an individual's right to self-defense. It does not bar the people's representatives from enacting laws consistent with our nation's historical tradition and regulation that ensure public transportation systems remain free from accessible firearms, end quote. Don't you love it how judges just say, hey, consistent with our nation's non-existent historical tradition of regulation, and then just drop it in there. Kind of like how people always say, look, I own a gun, but here's 30 reasons why all firearms should be banned, right? Or I'm pro Second Amendment, but, right? There's always that but, right? Addressing the lack of, laws that are directly analogous, which the Supreme Court says that they need to have, the court held, quote, we are asked whether the state may temporarily disarm its citizens as they travel in crowded and confined metal tubes. Unlike anything the founders envisioned, we draw from the lessons of our nation's historical regulatory traditions and find no Second Amendment violation in such a regulation. Cool. So basically, anybody who's relying on mass transit, you're done, you're out of luck. So presumably we're going to be really hitting certain demographics, probably by age, by race, by where you're living, by income level, a whole bunch of people, because of what a bunch of judges here have decided in the Seventh Circuit Court of Appeals, are going to be grossly disadvantaged versus someone taking a car, not living in a city, you name it. Apparently they're on equal footing. Remember that next time someone tries to push mass transit. It's mass regulation, as you can see here. This case clarifies that, quote, everyone agrees that the plain text of the Second Amendment as interpreted by the Supreme Court covers the plaintiff's desire to ride public transit while carrying a licensed concealed firearm for self-defense. The government, however, met its burden to justify the regulation, they claim, by demonstrating consistency with the nation's historical tradition of firearm regulation. All right. There you have it. Of note, there was a judge appointed by Trump on the 3-judge panel, because the way that this works generally, there's exceptions to everything, is that you've got all these different federal circuit courts, and they generally cover more than one state, sometimes many states. And you may have a dozen to a few dozen judges within a circuit. Every time a case goes to them, there's a random panel of 3 that gets polled, and then those 3 judges will hear it. So you may have a circuit that could have 20 judges on it. 17 of them were appointed by Democrats, but theoretically you could get a 2-1 Republican to Democrat panel here. So you can see how this sort of shifts and evens out over time. The 7th Circuit, however, is not a firearm-friendly circuit. We're talking about Illinois, Wisconsin, kind of that part, Wisconsin, my home state, that part of the country, okay? There was a Trump appointee who concurred, in other words, jumped on board with, at the end of the day, the final conclusion, but highlighted, quote, a difficult jurisdictional question, how to assess redressability where a plaintiff defines her injury as the inability to engage in protected activity, and an unchallenged law also prohibits that precise activity. The judge appointed by Trump agreed with the outcome, but noted that issues of standing and relief were prudently reserved. At the end of the day, she's on board. Okay, at the end of the day, she's on board. Do you want to see a video where I just do a whole breakdown, by the way, talking about Democrat versus Republican appointed judges, even if I can get it, information about judges appointed by different presidents and how they've ruled in the Second Amendment? Hit like and comment down below if you want to see something like that. That could be interesting. The court wraps up this decision by saying, quote, we hold that the law is constitutional because it comports with regulatory principles that originated in the founding era and continue to the present. Right. Regulatory principles. That's code for they've got nothing. Otherwise, they would have specifically put it on the law. But you can see through this. You can see through this, folks, to see how they are setting up massive gun control down the line. Because if you buy off on this reasoning, there's no limit to where this could go. And where this could go, by the way, could be the United States Supreme Court. We'll see if the Firearms Policy Coalition, which is a fantastic organization, always encourage all of you to check it out and join. I am a paying member myself. But you can see where all this stuff can really grow and just migrate, unfortunately, to have, well, in the 1 second we're talking about Chicago mass transit, and the next second we're talking about anything where there's a bunch of different people who are there. And suddenly, hey, is that restaurants? Could that be grocery stores? Is that basically anywhere out in public? Because rest assured, that is what exactly the gun grabbers want. They want them banned from everywhere possible, and they're going to incrementally chip away until they get there. Be sure to like, share this video around. Let me know down below what you think about it, as well as if you want me to take a deep dive into the analysis of different presidential appointees. We're going to close out with our ever popular quote of the day. This one comes from Greek thinker-philosopher Pythagoras, who said, "Silence is better than unmeaning words." So make those comments count. I appreciate it. I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.